I came back hoping to you about an institution which he communicate had never heard of. It was discharged by breach. If that was its a contract, and one of the parties then tells the other it will not fulfill its obligation. They, in English law, the creditor, the one who has been told, has two alternatives. Either wait until the time comes when performance is due and can ask them for attitude, or he can immediately say, all right, I was fed up with it, I to bring your contract to an end and get damages thereby. What you can't do is wait and perform your contract when you know that the other one said, I don't want. Is that clear?
See.
It's nice to see it for again. I'd also had the unsuccess with it or that word it. Where I stopped mine today, it with the aim of contact needed damages. If a contract broke, the remedy is damages. Specific performance, which is an order of the court, the data must do something, is only granted very exceptionally if damages are insufficient remedy. But on the whole, the court cannot order you to fulfill your contract. You are not slaves. The same if, in fact, you had pursued for them. And that is, of course, the case. You see that through a French law with us. And the Germans should keep in mind that so they have something which tells them they had specific performance. If you look at the Article 88 of the civil procedure, you can't get any more than that. In England, dating from the time when damages were assessed by juries in civil cases, which had to be instructed by the judge, the assessment of damages is not just in the discretion of the court, but it relies on two separate principles. The whole he has to claim is a contract or a tort. In contract, the damage must have either arisen naturally in the usual course of things, as say objectively, or it must be within the reasonable contemplation of the parties at the time when the contract was made. Natural result is clear. Whatever damages are also from a breach and be ground. But the other one causes certain difficulties if it is the natural consequences of the contract. How do the back gets back date? I gave you, I think, this example already, and I finished that. Am I repeating it? As no, not. And in this case, I've given you an example, I think, before. There's a piece of machinery, a machine in West England broke down, and the owner of the factory said it by rail, the landlord to be repaired. They waited too long and didn't send back time. And the fact they had to stop, they lost a lot of money. And so we asked for damages for the lost time where we couldn't produce. Answer. That is not a natural consequence if you send a piece of metal by rail to London. You have to tell the other side, but if it doesn't come back within so many days, my factory will stop. In tort, where of course there's no personal relationship between the parties before the damage is done, you can't tell the other side what you will expect as damages because you don't know who effect is due. So in that case, it's not the particular damage, but the natural consequences of the act. Finally, one has to keep in mind certain terms of English law which you may not find easy. Liquidated damages. This concerns damages which are fixed in advance in the contract as the so-called genuine pre-estimate of the damages. So you make contract with somebody and you say, I estimate that if you do not perform supply the machinery within so many days, my damages will be the following. A genuine pre-estimate damage, and you put it into the contract. If it is not performed, that amount of money should be paid. It's called liquidated damages. And then there is something else, exemplary topic. That stands is to punish it out there. Because of that, there is no other egg. So much about contract. But there came something else. It's called quasi-contracts. If there's an illegal or invalid transaction, and you have performed something, you all know that you have a condictio indemnity or procedure causa data causa non secuta. We remind you of that? You all know you know. We haven't got there. But still, we have ways it were developed by the courts in the 18th to 19th to 20th century. The great example today is Lipton Gorman against Cartney in 1991. Here, a solicitor who was in charge of the finances of his partnership used the money to gamble. In other words, to do games of hazard. And as you may remember, and may I remind you, don't do it. You always lose. And he did. The result was that the institution got the money, he lost it, and his partnership found out. And what do they say? By English law, gambling contracts are illegal. Therefore, you, the gambling club, have got illegal promise about profit, and therefore you have to return. And thereby you see, return of money A that causes an illegal contract. And we have many such cases, and even give you all of them. Where people make contracts in order to offer can be kind in order to avoid Monday, or the famous one elite type, which I can't quite understand because I no longer a good banker. So postpone contracts which a legal whooping backs may have paid the contract in legal in the money has changed. All that is known as a trade in quasi-contract, because there is no contract, because nevertheless, on the basis of illegal or invalid contract, money has been paid and it ought to be returned. It remains a question whether this is a general rule in English law or whether it is limited to a number of cases, which I shall now give you to you, although I'm not sure whether I can say it's a general principle to say. This claim, native unclassy contract, has been allowed where money has been paid to what we say to the latest use. If the importer of tobacco, you are importing it, it comes to the customs house, the customs demand money to be paid, and before you to do it, your carrier pays the money so she can get the tobacco out of the customs house. If he come back to you and say, money I paid for your use. Understood? Certainly, you should recover a quasi-contract if the money is paid under a state of fact. Kelly against Solari, where the pairs thought she was under obligation to pay the tax, and in fact they weren't there. And finally, in the case of so-called total failure of consideration. Total failure of consideration I dealt with you when I discussed consideration. It means that while we wanted to make a contract and we thought we had made consideration, there was no consideration and I had paid nevertheless, then in the absence of consideration, I get the money. Will be against Lord. And then another quasi contract. Money paid received from a third party to the plaintiff's use. This was the following situation. The government paid a bank a certain amount of money to pay the pensions of their labor admirals. The admiral could claim from the bank the money which the government had paid into the money for their use. Finally, if you had an action in torts that the defendant has got some property of yours, you can, instead of that, sue in quasi-contract to get the contract, the required money back. In more recent times, whenever the contract came to an end because of changes circumstances, rebus extensus, there was no recovery of money which was paid under a contract. That was introduced in 1942 by special legislation. So far, actions for quasi-contract. But then there's another one. It has a lovely Latin name. Quantum merit, for what he deserved. Somebody made a contract with a publisher to publish a book or Turkish states. And the last moment the publisher said he didn't want the contract. Look, instead of suing for damages, the writer said, I have spent so much money in preparing that book and I want that amount of cost to whatever I so far merits to be given. I now turn to special contracts. Special contracts, which are governed either by binding rules or supplementary rules, because they imply, are the following. Sale of goods. and that is the most important one and is covered by legislation. Secondly, what we call tenancy agreements. That is louage in French law, miete in German law. It's any kind of contract whereby you are allowed to use a premises. Partnership, bills of exchange, checks, insurance contract. Of all these, of course, sale is the most important. And also most interesting in comparison to me. It's codified by a statute begun in 1893. The latest provision is 1994. And it has separate, this definite feature. It deals only with sale of wounds, not with sale of land. Sale of land is our purely exclusively that optic and I'm not sure whether I should be able to talk to you about land law, but I'll tell you why. I've told you too much too slowly, and I cannot follow and do everything as I wanted to, including land law. So I warn you, I may not give you say the land. It's high tech. The main distinction between English and constitutional law of sale, a continental law of sale of land, of goods, not that, but goods, is that English law treats the question of absolute of title or quantity, the two remedies which of course you know yourself in the law of sale. It deals with them under the heading of conditions and warranties. It does not introduce what you know in your leases, that if there's a lack of title or a lack of chorus, you have two possible actions, namely to rescind the contract or to ask the reduction price. That's Caution minoris or that restitutoria implicit erroneous law. We haven't got that. What we have instead, so don't believe that you can either ask for a reduction in the price or to return money returned. Instead of that, we have, as remedies, something called conditions and warranties. Don't think the condition means what it normally means in contract, which is say, unless I could have jumped over the moon, we won't get the money. That's a condition. A condition here means a right to rescind the contract. And a warranty means a right to ask for damages. And so the purchaser has either rescind or ripple claim damage. But conditions can be waived, so you need not rescind the contract to say, I want damage against. What are the sub-point conditions so you guys say more? Namely, that the seller should have the right to sell his goods. He doesn't, you can rescind the contract. That the speaks, if the goods are sold by description, that they actually comply with the description. And if the purchaser tells the seller for what purpose he needs the goods, then if they fail to supply him because conditions, he gets with these terms, he could get rem. In scale sale of in course of business that the object has satisfactory quality, which you know exactly, the owner or same goods. And I need not go more. Warranties, which is where you could only claim damages, is rather more lenient. You get damages because the seller has promised that the object will be free from charges. In other words, there's nobody else as a trade for goods. And or is there charges, meaning the seller has a right to trade over it. I sell it to you. You have to tell the buyer. The right to reject goods is lost upon acceptance, and the right to damages remains for the normal debit and contracts under the Libertation Act 1998. One thing you've got to keep in mind, reduction of the price as you find it fits through the term of EPP or the Uniform Law of International Sales has no place in English law. You either rescind the contract or you pick them. Title to insert, title to the goods, passes with the conclusion of the contract. In other words, there is no need to hand over the object. Title passes with the conclusion of the contract. The risk passes with the transfer of power. The two goes together. So that once title passes, then if the object is destroyed by accident, the risk is no longer on the seller, it's on the buyer. But this may cause tremendous difficulty, and I'm not sure whether I can make clear to you. But I tell you, we're tough into a lot of funny situations. I said that title passes with the conclusion of the contract, risk is the buyer. The retention of the title may be very important for the seller because he assures him that it's the buyer that A, he retains the ownership in the goods. But he may at the same time, the seller, be anxious to shift the risk of accidental loss to the buyer at the quickest moment possible. So you have two things. He would like to retain his title, and he'd like to shift the risk to the buyer. If, therefore, in general, ownership passes with the conclusion of the contract, and the risk passes to the buyer, the seller cannot pay anything. So that if title has passed early, and it's passed it, the seller is no longer owner. This is the difficult case. Perhaps I shouldn't worry you too much. In certain circumstances, when the seller cannot recover the good or the damages which he has against the buyer, because the risk had passed, ownership had passed. Nevertheless, sometimes the new buyer, if he makes a claim in respect to the goods, does so, in fact, for the benefit of the original owner, and it's no new journalistic, that's how they put that so. There's little protection for the buyer who buys goods from another in good faith, which did not belong to the seller. So there you are in a very different situation from the German and Swiss law, where a buyer in good faith can acquire a title for a non-owner. Not so in English law. There was once a possibility if you bought from us in the city of London, from a seller in a particular types of goods or something which belonged to a third party, you couldn't become the owner because you acquired in what is called market ouvert, open market. But that's gone, and you cannot acquire in good faith properly belonging to others. So the German 1932, paragraph 1932 equivalent Swiss law doesn't apply. And you can't either rely on the famous French maxim, en fait de meurtre de la possession. It does not. And I now turn to one of the most different matters, but one of the most important of the English law, torts. Although we argue that there has been much argument in recent times whether there is a general principle of liability in torts for unlawful damage, or whether there are only individual torts, you may say, nonsense, we haven't got that. Article 138 French Code, the evidence was damage to another's life to make it good. Paragraph 823, the job Swiss, so we're all saying the same. We are not sure whether under get would largely be open. And give it see now what. In short, the tradition which in Europe is based from the Lex Aquilia Digest 9.2, a general rule, is promptly not badly is law. On the other, the law of tort is more important in English law than anywhere else. And you'll see why. The contract is limited in use because of the technicalities of the concept of consideration, which for instance ignores contracts that fail with parties. The absence of any provision allowing you to torture. Up to the end of the last century, protection was accorded not on general rules, but for specific types, and we live by that still today. First of all, intentional interference with the person. This is negligent, and negligent run you down in a motor car is known as trespass, so it's actually negative. If it's done intentionally, it is called trespass. And there are plenty of cases that needs to merely to intend to do damage to somebody else may not be enough for claiming damages. That is still a great problem based on the case of Wilkinson against Townshend, 1897, where somebody, in order to annoy another, told her that her husband had suffered a terrible accident, when in fact he hadn't.
On each side. Oh. Or
so, intentional negligence exam that is trespass or negligence. Uh, Non-physical damages. Armand is the purpose is deceit. When I tell you a false story in order to get you to pay me some money, I have deceived you. You haven't actually been taught. So they have introduced to the person willful or negligent, intellectual deceit, or now one which you have never heard of before. Intentional interference with contract. I'm afraid you're getting nothing but new things. At the end of this hour, you'll be absolutely exhausted. I should be too. Long-legged guy. This is a 19th century case in which a German singer, made a contract with one opera house in England to sing that. And the director of another opera house persuaded her to break her contract to Opera House 1 and come to him at Opera House 2. He was liable for inducing a breach of contract. The fact that he had persuaded somebody to break a contract can make you liable in damages. Then there's intimidation. This is pain. Supposing you had a ship and you use as a crew of people from countries which have no trade union and whom you pay that sort of ship. It is quite usual to that with people tummy Philippines. If you that ship will go into a country where there are strong trade unions, they may object to, and they may stop your ship, not allowing the ship to leave, with the result that you either lose a lot of money or you have to promise your crew to pay better. That is intimidation, and you may be liable for doing. Similarly, if two parties agree to a certain course of action which causes a third party illegal damage, can still say you are liable to. So we have already quite a lot. Conspiracy means that you agree to do a certain thing either by unlawful means, you threaten to stop their machineries, or with an unlawful purpose, namely in order to make gas. But on the whole, trying to ruin your competitor by undercutting and pay a New York or satirical tetra is your very good right of competition and is not illegal. And fine. One thing which probably again will strike you as a story. Defamation. Defamation which for you in your country probably mainly criminal. In England it is a passible action. And what's more, people of it. Is I hear only once that it says, but a well-known law professor in Cambridge had been stopped at customs eaters carrying a lot of heroin. And I can prove that everybody thinks it's me, and that my reputation has been ruined. I already what? I can get damages. It's known as a gold digging action. You may appeal. And there are two types of defamation: libel and slander. Libel is a libellum, meaning written, and you needn't prove damages if the damages are obvious, or slander, which is spoken results. where you have to prove them. So here are a number of the talks which you could sue on, which were developed over the centuries. And these are ones that are in the plot. That there was also interference with property. Direct interference with property. You take my bicycle, half a criminal, is trespass to good. Or if you keep my bicycle, which I bent you, that and you fail to restore it, you may be liable for conversion, for keeping property.
It's now 1977.
And there is towards to land, trespass to land. If you will come into my garden, you are liable for the action for trespass, and a lynch or in particular damage or automatically leads to damage. It may be very small, and it may cost me more to sue you than I get. But trespass to land is be like it action. So if I could have and I put down one at the paper photos and paint bottles, you come in and interfere, not taking champagne, but using a garden hose, spray water all over the place, so nobody could come and drink the champagne. That would be trespass to that. Oh, and they can escape. Malicious nuisance is any interference with one's enjoyment. Bradford against the city of Bradford was establishing a water supply. Mr. Piggies was nearby and he had a wonderful fountain. And we were very much afraid that he will do. So we ducked at Melody with the result that the water couldn't reach the city of Bradford, but would be on his lands. And Bradford sued him for damages because he intentionally wished to cause damage to the city. A Christie against slave. Somebody had a neighbor who was a fierce keeper. She didn't like hearing that noise. So the cursed Buddhist neighbor wrestled on the walls for hours on end in order to stop the music teacher teaching music. That is deliberate action with news. Or the famous one on the silver fox farm that gets later. There was a silver fox farm, and the neighbor didn't like it. I don't know what smell or anything else. So what he did was he started shooting with guns, making a terrible noise, which meant that the person who had silver foxes next door hoped to breathe up to animals and could use their fur. They suddenly could breathe it, and so he lost his business, merely because the other one shot it on his land, which you're perfectly entitled to, provided you don't intentionally damage somebody else. And data are so-called public nuisance. Interference with members of the public in game. You don't like my business, and so you organize a big meeting outside my shop because you think I'm acting more. That might be public nuisance because nobody can walk up the pavement or in the street while you are having it below reaching outside. That is public. And then there is the famous rule in Rylands at if you bring onto your land objects which do not know where belong and they escape from it, you are land. So if you start on your land a pond of water because you like some ducks to swim in, and the pond breaks and the water runs down the hill onto your property and damages everything, the alarm will cost, not because they already did anything, not because of occasional negligence, but because the other person brought something onto a lamb and it had caused them. In other words, the accumulation of non-natural sin. And then we have a lot of legislation about dogs, dangerous dogs, and they liable.
Up mean that room. I see that any. Nope.
That's only one. It is the action for defamation. And again, it is one which is quite not true, because it brings in a open knowledge of cut, and you always find in laws of force some who sue it the lies of Ostata. In other words, I'm accused of having beaten up my wife, and in fact I've never done it, but the newspaper says they have. I could bring an action for libel. Libel means written defamation. Slander means spoken defamation. And if it's written defamation, I mean into damages, because it's there, it's forever. Everybody can see it. If it's slander, spoken, I must prove my damn to. So if you accuse me of beating my wife, and you do it only by carrying my affairs, I have to prove damages, and I find that very difficult. And then there is something you don't know whether we have that or not. The action for privacy. If you try and bring a camera into my garden because I like a private garden where I can sunbathe in the nude, and you bring in this aerial camera, then I might be able to sue you for damages for interference with my private life's privacy. But it's by no means clear whether we have that action yet. We certainly at the beginning in the case brought at nearly 200 years ago, in the case of the husband of the queen, with Albert, and who tributes were copied outside. It said that he was allowed to action because of interference with his private life. It's much more famous in American law, where there are famous articles of privacy, especially by Brandeis for Amador. More recently, new thoughts, so-called Euro thoughts. They are based on the violation in a particular country of rules made by the European Commission, say on how to make contracts to the exchange of trade, the lot. All this happened in the 19th century and up to now. And it still is at your disposal if you want to see. But now answer you to it. Donahue's scheme, has elected you, for example, the snail in the pot. You heard by had that already? Mr. Weir all the way. So need I set you a story again? Where a lady went into a restaurant once later asked me, oh dear, she got it. When she opened it, because briefly she found a dead snail in it. And that gave her such a shock that she giggled and she wanted to sue. And she wanted to sue. And the rest. Is he nuts? You see, Hillary comes to the equipping for copy and since the days of Rosen laws, the lexiconia, whoever those guys to another will feel a negative, they should be that we could 38 jewels fit the blow. What did the court say here? You must avoid acts or failure to act, which you can reasonably foresee is likely to injure your neighbor. You have to think when your action, whether or not there is a likelihood that your neighbor. What is your neighbor? And this question. It's a person who is within your reasonable contemplation. And therefore we suddenly found in 1932 a new type of action which said that if we interfere and cause damage to another way, could reasonably think that the neighbor would be harmed, you are out. Now comes the one for us. Where does this come from? It comes from the House of Lords. But the House of Lords is our highest court. And this court of appeal no longer from England, but also is. And this is an appeal from Scotland. And Scotland has Roman law. And this is, in fact, bringing home into England the old good lexiconia, but now in the form of the English rule. And we have lived ever since with the question, is it foreseeable that you could make that by mechanical? Will it affect a person to have to consider your neighbor? Who is your neighbor? Because it doesn't mean just somebody sitting next to you. And the amount of problems is therefore enormous. That the Germans will realize that Cheesy, who is my neighbor, killed Cheesy. But Donald Stevenson was the beginning, 1930.
What did it mean?
Actions for shock. A lady hears from a messenger that her husband and his children had a road accident and one at bad injured picture. She has a terrible shock and she tries to sue the person who's called death. Tony Stevenson, you had to consider if you run down somebody, if some deaths would get a better shock from the family. Doctors who find that they have a patient who has rubella, which I don't try to counter. It's an illness which could affect badly any babies who you carry. He has to tell the future mother that there is a data here the child to come, and that for you to all with defects and must drop out when she doesn't need back for work. If he fails to do so, the child is born. Is he capable? Is she? The doctor is liable. Sterilization. The doctors who sterilize a husband who says had enough children, doesn't want more, and after that he has another one. The doctor may be liable if he either did it badly or failed to point out
that he has to wait as a period.
On the other hand, if you injure me within the sense that I had my whole personality changed, and I now become murderous and run around the cats of murdering people, you can't sue the person who done me down for having caused the murder of third party. So much about person. But also property damage falls under the next spell of an audience speed. If a cable is cut of an electric cable, you could only sue for the economic loss. In other words, the cutting of the cable. And if the city is under an obligation to control buildings for health reasons, and they fail to do so, you cannot sue for damages except if the failure to carry out the instructions of the city for building led to actual health defects. But other things can also lead to death and Kurt Lipstein. Yes, I should put it out. Misleading statements. If I make a statement to because the bank asked to give a statement whether I am sufficiently responsible financially to want to send me a car, and they say I am, and it turns out that I am in fact bankrupt, the bank will be responsible for making a statement, a wrongful statement. Even something before the act occurs can be cause liability. It's very much like some country could buy in contract and bill. If I'm told by an oil company when I want to put a peg restriction that I will be able to sell 10,000 liters of oil a month, and I had to find out that I cannot, and that the oil company told me that mistake, they are liable for having made a fault in practices. It's something which the Germans knew as who by a contract and don't know what they say are the cuss. And things at three. If I tell my solicitor that they must make a will whereby they babysit my much beloved girlfriend, and the solicitor is slow and doesn't do it, Naita. And my girlfriend now doesn't get any money. She turned round and sued the solicitors because she said they had a deficit kind of this under George Stephen as the nearest neighbor, because she could see she was going to benefit. If she actually just break that equal she would do it. That has led to quite a number of cases where people who are solicitors of dollars who fail to carry out this stuff were held to be liable to the beneficiary if they got done. Similarly, of course, somebody tries to take over your business and tries to find out when the business is sold, and he goes to the accountants to find out, and they give a favorable answer, and the answer is mistakes. here comes this now. We had an enormous amount of repetition in cases where buildings were put up which should have been built in accordance with certain instructions by the local authority, building instructions, and they were. And when the building therefore had been built, the owner tried to sue the local authority, but having failed to control the building. Answer: if you haven't got any damages, and damage, there is no action. So, failure, a duty towards your neighbors does not do any action until you stop her, but some time of death. The chief of police of an area is not under a definite duty to protect you against interference by criminals. So that if you are murdered or injured or anything else, you cannot turn around and sue the chief police for having failed to protect you. There is no general duty to protect
that on the public authorities the key.
On the other hand, you always have to work out, is there a special relationship which creates you as be the neighbor of the other one? If somebody has a building which is closes down, and because he wants to pull it down, he is a big. And while this is happening, people trying to get into the building and trying to make mischief and to put out a fire. The fire spreads and it spreads to the neighbor. Can the neighbor sue you for having failed to stop the interfering towards people? The answer is, it depends to what extent there was a relationship of responsibility to you and the. If on the other, you are sold the house, and it turns out this title is wrong, and you can't move it, and so you have to go and hire the house in which project. And if you happen to be too poor to pay the money, can you sue the party who sold that house? You but sue for damages because he couldn't sell the house, had to go somewhere else. Answer: no. Damages. At Bill, I had an overshooting outside. No specific damages need be owed if the court is what we say called actionable third seas. There are certain types of torts where damage follows automatically. If you move into my garden without my permission, I can claim damages from you without proving penalty. I get half 50p. I wouldn't get much, but I kept that day. There was a time when if I had a ship and the ship was damaged by and I have an action against a visa illegally. And Thereby I lose a good project because I had promised that my ship would be used in the next 10 years in trade with China. And now I can't because the ship is being repaired. Question. Canon 2. Answer was given in 1933. The fact that you must repair the ship and that it costs and may cause you damage, but you cannot say I can claim damages because I'm too poor to pay for the repairs of the ship. In other words, if you suffer damage and you're too poor to have the matter repaired, it used not to be a claim for damages merely because you're too poor. That has been overruled a few weeks ago. Several people are alive called neglecting and damaging my logical. The liability is divided between. We have no partie civil proceedings as the French have, where in a criminal proceedings you can have yourself to pay. But as Criminal Justice Act 1972 does allow you certain amount of